All right, let's get started. This is our, I believe, third and final book panel of the semester, which is a testament to our incredibly productive faculty, and we'll have more next semester. Today we're celebrating the publication of Brad's book, Lawyers and Fidelity to Law, which is published by Princeton and presents a really interesting and new theory of professional responsibility. And we put together an exceptionally good panel, I think, for our final book celebration. I'm going to introduce them all before they start, and I'll do it in alphabetical order, and they'll speak in alphabetical order, which is an order that Ben Zipursky either loves or hates, I think, depending on what's being distributed. Our first panelist is Robert Gordon, who's the Chancellor Kent Professor of Law and Legal History and a Professor of History at Yale University. He was twice blessed at Harvard, went there for college and law school, and is the author of dozens of books and articles in legal history with a frequent focus on the legal profession, and I think in what was surely the highlight of his career in 1996, taught me legal ethics at Yale. So he'll be speaking first. Our second speaker, joining us on a long journey from Tucson, is Professor Ted Snare, who's the Milton O. Riepe Professor of Law at the University of Arizona. Also a graduate of Harvard Law School and visited at Cornell in 1997. So this is a reunion for him of sorts. And I think overlapped. Did you two overlap at the University of Wisconsin? Or?
Yes, we did.
Both taught at the University of Wisconsin before ending up at their respective institutions. And also the author of dozens of articles on professional responsibility and the author of the book, The Lawyer in Modern Society. He's also, I think, previously served on the committee responsible for drafting the MPRE, which Brad, I think, continues to serve on. And finally, my colleague, Ben Zipursky, who's the Associate Dean of Research and the James H. Quinn Class of 49 Chair in Legal Ethics at Fordham Law School. Ben has taught as visiting professor at Columbia and Harvard and Vanderbilt. He's a leading scholar in a number of fields, torts and legal ethics and jurisprudence, and has published more than 40 articles and chapters on subjects ranging from punitive damages and duty and tort law to varieties of pragmatism within legal philosophy. He's lectured extensively in the U.S. and abroad and is the author of a leading torts casebook and the Oxford Introduction to the Law of Torts, and his articles have appeared in all the leading journals, most recently in both the Harvard Law Review and the Yale Law Journal. So that's the order they'll speak in. Each of the panelists will speak for about 15 minutes, and then Brad will have an opportunity to respond, and then we'll have some time for questions and answers, and we'll finish up at promptly at 1:45. So, Bob?
It's nice to be back here after many years in a place where I have many old friends and know many others by reputation. And it's particularly nice to be back here on this occasion to celebrate this book. This is an important and I think in its own quiet Wendelian way, an exciting book. It's written with exceptional clarity. Like the best of advocates, it makes its arguments in a kind of low and reassuring key, taking account of rival arguments and plausible objections to its own position, and but thereby making its conclusions seem sensible and indeed almost inevitable. And it gains in persuasive power from its use of concrete examples, not the usual philosopher's examples. You will not find any trolleys in this book or any sparsely populated islands. But you will find many examples of real lawyers' dilemmas in practice. And if there's any justice in the world, and I'm not altogether sure these days that there is, this modestly presented thesis should have an effect, and I believe a mostly beneficial effect, on how lawyers understand to what and to whom they owe their loyalties. Long before I met Brad, I was reading his stuff, and I felt a great affinity with his ideas, and my feelings of that affinity and my admiration for his work are only increased by the experience of reading this book. Now, the core of Brad's argument here, of course, is that lawyers' primary obligations are to the law, or more precisely, to their clients' entitlements under the law. This view of lawyers' obligations, I must say, seems almost self-evidently right to me, though it departs significantly from the way in which most American lawyers actually seem to understand and articulate their role, which is that they are zealous servants of their clients' interests. Sometimes adding, but only in parentheses and sort of sotto voce, within the bounds of the law. Agents whose sworn obligations are to help their clients press their interests up to the point where clear legal prohibitions unambiguously impede them, and even then to try to soften up and game those impediments for the client's benefits. As Brad says, this view of the lawyer's role as a sort of all-purpose autonomy engineer hired to hack a path for the free passage of clients through the jungle of law is the result of an unfortunate migration of the role of the criminal defense advocate into other contexts of legal representation. One historical project that I have very much in mind someday is to try to figure out how and when this migration took place. It's a very interesting development, the generalization, the beyond the litigation context of an ethic which is really suited only to that context. The criminal defense lawyer is, of course, a very special case, a lawyer who's given exceptional latitude to exploit ambiguities and procedural opportunities and opponents' mistakes, because the rights that criminal defense lawyers protect are thought to be so critical for protecting all citizens from state oppression that they can trump the goals of finding the truth and doing justice, and also because, as a practical matter, the defense lawyer's role is actually pretty tightly constrained by trial procedures and by prosecutors who control the investigation, have lots of power and resources. The criminal defense's latitude is really a kind of a weapon of the weak. Now, the latest edition of Monroe Friedman's Understanding Lawyers' Ethics, now co-authored with Abby Smith, arrived on my desk yesterday, and I had a lot of fun reading it side by side with Brad's book. Friedman is happy to extend the criminal defense adversary role outside criminal defense to all litigation, and indeed outside litigation to transactional and counseling practice as well. But he does not really provide any satisfactory explanation for why the criminal defense law should apply in such different contexts, where its principal effect is likely to facilitate clients' evasions of law. To be sure, some lawyers in bar committees of a libertarian bent seem to take the position that all government regulations and taxes are presumptively illegitimate and inefficient interferences with markets and private activity, which the citizen is entitled to resist by any means available, including covert nullification aided by lawyers, such as, for example, advising a client to claim a far-fetched basis for exemption from a regulation or tax in the expectation that the overburdened regulator will never find out about it or have the resources to contest it. Friedman thinks the advocate's role is still justified in this context because there's always a chance that someday there may be an adversary proceeding, but this isn't much of a constraint on the advice if there's no adversary ever likely to contest the claim and no authoritative adjudicator to resolve it. The advocate's role, I think, is construed by Friedman, and indeed I think the majority of the profession allows clients to make law to suit themselves rather than respecting the law that is made by authoritative lawmakers. Brad argues, and I think he is right about this, that justifications for straining law to its utmost limits of plausibility for the client's benefit, rooted in such values as preserving relations of trust and confidence with clients. This is Charles Freed's lawyer as friend, which Brad actually does a heroic job of rescuing from absurdity with a sympathetic reinterpretation of it. And fostering client autonomy for its own sake, no matter how the client may be using that autonomy and how many others he may be hurting in the process, is also an inadequate basis for a lawyer's ethics. Brad actually, I think, rather tends to play down how sharp his disagreement is with large segments of the practicing bar on many of these issues. But it is, in fact, very sharp. Adopting his ideas would entail major changes in lawyering attitudes and practices. In a very interesting section, for example, he takes issue with one piece of standard lawyering ethics that seems to conflict with the general principle of non-accountability, that lawyers are not responsible for their clients' ends. As Brad points out, that principle is actually hard to square with lawyers' absolute privilege to decline cases and clients on moral grounds. If you can choose your clients without restriction, if there's no cab rank rule, how can you not be accountable for their ends, especially if you choose such clients repeatedly over a lifetime? Brad's view, like my own, is that the lawyer is not a freewheeling autonomy agent of clients, but rather an agent of the legal system, licensed to press on behalf of clients for all that the legal system may rightfully help them to obtain, but for nothing further. One important consequence of this view is that when lawyers act outside contexts where claims can be practically tested by adversaries and adjudicators, their advice should be conservative, remaining well on one side of the boundaries of potential unlawfulness. The adventurous, innovative, forward-leaning positions should be reserved for genuinely adversary settings where they are appropriate. Brad, however, also wants to separate himself from legal ethics writers like David Luban or Tom Schaefer, who think that an adequate legal ethics cannot begin and end with respect for positive law, since, as they point out, positive law may be very unjust, and who therefore urge lawyers not to allow themselves to use immoral means to help clients to achieve immoral ends, even if positive law permits them to do so. He distinguishes the position also from that of Bill Simons, that the lawyer should seek to achieve justice within the terms of the existing law. Simon bases his ethics, as Brad does, on the law rather than on a moral basis as such, but also thinks that the law is open-ended enough to incorporate many moral claims, if understood as a Dworkinian interpreter would understand it in light of its best purposes. I'm actually still not sure, even after having read the passages many times, how Brad distinguishes his argument from Simon's, but and would welcome some clarity on that point. Now, in Brad's view, law binds lawyers and their clients not because it is moral or even because it is just, it often is neither, but for political reasons. The law at any time represents a provisional political settlement of conflicts between conflicting interests and claims of right. These settlements are indispensable for coordinating social activity and preventing endless friction and warfare and protecting security of expectations. And their enactment thus offers adequate reasons for citizens, and I think this is probably especially true, although Brad doesn't stress the point, for citizens of a moderately democratic polity, to comply with law, and for lawyers to use it as a basis for clients to act, and also as a basis for advice that constrains them and sometimes disables them from action. He's certainly enough of a legal realist to realize that law is full of conflicts, gaps, and ambiguities, and is open to interpretation and negotiation, and also that it is dynamic and open to change and arguments for change. He does not accept, however, that law is so radically indeterminate that at any moment it may be manipulated in the direction of whatever results that any client may wish out of raw self-interest and naked preference to drive it towards. On the question of law's determinacy, I'd say he's situated somewhere midway between the most nihilist versions of realism on the one hand and neo-formalism on the other, in a place, I think, rather resembling that of the legal process school of the 50s and 60s. What the law is at any given time is whatever is in the range of interpretations that are plausible within conventions established through collectively engaged in craft professional reasoning of officials and the private bar. John Yu's famous OLC torture memos, in his view, don't pass this test. They represent invalid legal reasoning, lousy lawyering, he calls them, because they are idiosyncratic and carelessly reasoned departures from legal convention. And, he might have added, they were produced by conditions that deliberately manufactured that idiosyncrasy by the clients, that is, senior Bush administration officials, decision to delegate responsibility for giving advice to an academic lawyer known for his extreme opinions and insulating his advice giving from more conventional sources of legal opinion, such as those of State Department and military lawyers. If I read him correctly, and I hope he will tell me if I don't, Brad also wants interpreters to read laws in light of their normative purposes. In this way as well, he is a faithful heir of the legal process school, and I think also a soulmate of Ronald Dworkin's, though more reliant on professional convention than on Herculean acts of interpretation. Well, since time is limited and it is an abuse of the commentator's function to offer only unqualified praise, I'd like to raise a few questions about matters where I hope Brad might be able to provide more clarity and guidance. First, most of what Brad has to say about lawyers' fidelity to law concerns arguments they may make or positions they may take on legal issues affecting the client. But of course, a very large part of what lawyers do is to represent facts on behalf of the client, or in effect to manufacture such facts. I don't mean fabricate, but I mean the make as an artisan bakes. As when lawyers prepare parties and witnesses for depositions or trial, or write opinion letters, or narrate and summarize facts in briefs and motions. Some of these practices, he says, though they may not constitute active deception or fraud, which is clearly prohibited by the ethical rules, nonetheless fail to satisfy the goal of protecting legal entitlements of clients because they mislead their audience or readers, and often in contexts where there's no way of correcting for these misimpressions. This is provocative insight and suggests a project devoted to elaborating an ethics of factual candor, which is suitable for different contexts of lawyering. This is a subject, I think, which the general field of legal ethics has not had much to say about, and it would be welcome if it would undertake to say more. I would very much like to see what that project might look like. Now, lawyers, Brad tells us, are to take the internal point of view with respect to legal reasoning. Positions that are excessively off the wall with respect to current practice conventions are ruled out. But legal conventions that make gradually plausible arguments that a few years before would have been ruled out of court may and do change. Obvious notorious example, you remember when the Brown v. Board of Education case first came up to the Supreme Court. Justice Douglas did an informal count, and he figured, well, looks like it's going to be about 6-3 to sustain Plessy. Certainly no one would have predicted at that point a 9-0 outcome the other way. Certainly not John W. Davis, the lawyer for the Southern states, who predicted 9-0 going the other way. Now, legal conventions change as a result, generally, of political actions. Social movement actions, the lawyers' actions, arguments that put new theories and policies on the agenda and recruit political and legal agents to support them. Lawyers are often among political change agents of this kind. They lobby legislatures and administrative agencies on behalf of clients. Their associations urge changes in existing law. They write provocative pieces in law reviews, urging new directions for the legal system. Now, a question that arises here, are there ethics which are special to lawyers acting as political change agents? Now, by definition, obviously, lawyers are not making arguments that are the conventional currency of the going legal system. They're making arguments for changing the conventional currency. To use the sports metaphor, they are working the refs. They're not just working the refs, actually. They're trying to rewrite the rule book of the game. Now, Brandeis, in his famous Opportunity in the Law speech, suggested that there were special ethics for lawyers as political change agents, that in urging legislative change or law reform, lawyers should put on a different hat from that of partisan advocate for clients, not be partisans for clients, but to be disinterested Republican citizens. If lawyers are under no special obligations as change or reform agents, what becomes of Brad's constraint of fidelity, understood as fidelity to craft limits on argument? An example I like to use here is lawyers' advice to corporate management facing a union organizing effort. The law says that firing the organizers is an unfair labor practice because facilitating collective bargaining is a public policy objective enacted in law. The lawyer tells the client that if he fires the union maid, penalties will be minor and long delayed. I'm not telling you to do this, he says, faithfully following the text of the model rules, but I am telling you that if you do it, nothing much will happen. Efforts over many generations of managements and management-side lawyers and consultants and practices of labor boards and largely Republican administrations have so eroded the public norm of the public policy facilitating collective bargaining that few any longer take it seriously. But they have never managed, on the other hand, to actually repeal the Wagner Act. What is the law here, other than the Holmesian bad man's law as a price on conduct, which Brad explicitly deplores? And what sort of responsibility must lawyers take for what has been the collective erosion, long-term, of a legal norm? The question just asked suggests another. What are the lawyer's obligation to fidelity to law understood as convention and craft-bound reasoning from the internal point of view, if the law is not simply a moving target, and indeed moving in directions influenced by its interpreters, that was the last point, but also founded on conflicting principles, structured, as we used to say in the heyday of critical legal studies, around contradictions. Supposing it's 1937, and there's a body of law that says that contracts are presumptively free if there are formal signs of party consent and no provable gross force or fraud, and thus it violates constitutionally protected liberty and property rights for legislatures to regulate them. But there's another body of law, which is imminent and ascendant, which says that contracts are never really free where there is inequality of bargaining power, so that legislative attempts to increase the practical liberty of weaker parties through regulation are presumptively justified. And in any cases, judges have no business second-guessing them. Or for that matter, are contracts simply options to perform or pay damages, or do they also incorporate into law moral obligations to perform promises? Which is the law, or are both the law? Because both are available from the common stock. Finally, although on the whole I agree with Brad that the morality of clients' means and ends cannot be the lawyer's primary concerns, I wonder if he might have more to say about certain aspects of lawyers' responsibilities that go beyond fidelity to law. One he alludes to briefly, that is, counseling clients in the direction of a Weberian ethic of consequences. The client is going to have to live in a world that has been affected by the client's behavior and others behaving as the client proposes to do. And if the client's behavior, though within his legal rights to engage in it, has the effect of weakening the bonds of social solidarity or mutual trust and a culture of respect for law-abidingness and the rights of others, should not the lawyer, in the interest of maintaining the social cultural infrastructure of law, markets, and democracy, have some duty to call attention to and try to deflect the client from antisocial consequences? This is how I understand the Republican ideal of the lawyer-statesman, not as governance by a small core of aristos in the public interest, but Tocqueville's and Lincoln's ideal of lawyers as curators of the rule of law and the social integrating effects of respect for law, at the very least, having the role of conservative maintainers of the framework, at best, refreshers and reformers of the framework. Not simply in their activity, the outside counseling clients, but within the counseling function itself. And finally, I think it would be good to say something about the lawyer's prudential role, another very conservative idea. The doctor should take care that her intervention does not make the patient worse. The lawyer should take care to keep the client out of unnecessary trouble. It seems to me kind of like the rock bottom basis of the lawyer's role. If possible, keep the client out of unnecessary trouble. I marvel in this respect at the lawyers who advised AIG's and Merrill Lynch's managers that even after the crash and lavish government bailouts, that there was no legal impediment to continue to pay out huge bonuses to the team that had wrecked the world economy. We now read their memos. We can now read their memos to their clients, thanks to bankruptcy, the waivers of privilege, and there is no hint of a note of prudential caution in any of them. If there were cautions uttered, they must have been outside the context of the memos. You could say the same of U-Bibes basing their advice to their government on the proposition that the president is Carl Schmitt's tyrant beyond and above ordinary law. These are moments that cause you to think, sort of strike your head and wonder and think, what were they thinking? And where is the cautious prudence that supposedly temperamentally characterizes our profession and the exercise of its traditional advice-giving functions? Okay, these are just some preliminary thoughts, and I would welcome Brad's remarks on them.
Pleasure to be here. Pleasure to be back here. The weather's not as dreary as I remembered in December of 1997. And of course, I live in Tucson now, so the contrast is sharp. And I must have seasonal affect disorder because the sunshine makes an enormous difference to my mood. But I probably could accomplish more work here than I do down there. Partly for that reason, as long as the lights are bright enough in the building. I have been following Brad's work for some time. I didn't start early in my attention to legal ethics and the law of lawyering, thinking about it very much from a jurisprudential perspective, but I started to get interested in that aspect of it. And for me, Brad's work and culminating in this book, which is a really concise presentation of matured ideas. I got started, Richard Wasserstrom, who's I think trained as a lawyer but also a philosopher, wrote an article sometime in the 1970s that took the position that was very critical of lawyers from a moral standpoint. For example, he had some cases in mind that he thought illustrated his point. He imagined a case in which a father went to a lawyer and asked the lawyer to write or rewrite the father's will, to write out of the will a son because the son had refused to go to Vietnam or had gone to Vietnam. I can't remember which. Probably because he had refused. Wasserstrom felt that it would be very immoral, essentially, for the lawyer to go ahead and write a provision like that into a will. And one thing that made me uncomfortable about that was that I thought there was an implied assumption on his part that the wide swath of lawyers or law students or people who were reading this article would completely agree with his sentiments about the evil of going to Vietnam and seeing that as a justification for the lawyer not doing the will. I think subsequently much more sophisticated work done by David Luban and Bill Simon. Deborah Rohde's involved too. I think Bob's on the edge of this, but he's paid more attention, I think, to the lawyer's responsibilities to maintain the integrity of legal processes than I think he has written in this particular vein. But in Luban's case, one famous case that he talks about is one in which a lawyer is asked to represent a debtor who acknowledges that he owes a debt but hasn't been paid. Lots of time has gone by, and now the statute of limitations has run on the creditor's claim. David Luban suggested that it would be quite inappropriate from a moral standpoint for the lawyer to represent the client and undertake to raise the statute of limitations as a defense, because after all the guy owed the debt, and from the standpoint of ordinary morality, it would be unfortunate, to help him avoid his responsibility for that. And in the case of Bill Simon came to a juncture where he started to want to express his ideas in terms of substantive justice and as opposed to ordinary morality, because he could see that it was quite controversial to criticize lawyers simply on the ground that they were doing something, helping a client do something that was immoral, when we live in a pluralistic society where people have enormous disagreements about the directions in which morality points. And he wanted to couch his thinking instead in terms of justice or substantive justice. And yet, when you looked at it, it seemed to me that he was still making similar moves as Lubin was doing, and Brad, I think, agrees with this. And let me just mention a hypothetical that I think he originally thought up, but that Deborah Rohde also wrote about, that I found surprising. But it exemplifies my discomfort with this kind of approach. The hypothetical involves a woman who was on welfare. She was studying, and it turned out that the people in the legal aid office, Deborah Rohde was one of them, came to have reason to believe that the woman had some in-kind income in the form of having a space to live in a relative's house without paying rent, and under the rules of welfare eligibility, that should have to be taken into account as part of your income. And if that were taken into account, it would either mean a significant reduction in the amount that the woman would receive, or possibly even put her over the line, and so she wouldn't receive anything. And Deborah's point was that this was a very deserving woman, just because she was trying to better herself, just the kind of person that you would want to be getting this sort of assistance. And it's a little unclear, but either she was saying, under these circumstances, it would be permissible, even though you knew that the woman was perpetrating a fraud on the welfare agency, to help to assist in that, or at least that it was rather obvious, but maybe an argument could be made. Deborah herself would call this an epistemological demurrer. I don't know nothing. That might justify this, and it would probably recommend in subsequent cases being careful not to ask questions of a client which might elicit the kind of information that would put you in that in that situation. And at the end of her analysis, Deborah said that the woman is very deserving, and obviously, and again, there was this, I think, a bit arrogant sense that everybody would agree with the moral sentiment that she was a lot more deserving than a wealthy individual who was seeking legal assistance to try to avoid taxes. She didn't even specify that it was to try to avoid taxes by means that were not legally authorized, but maybe that's what she meant. And it was stated just as a comparison. And in a critique I wrote, and also Monroe Friedman took this position, the Rush Limbaugh could agree completely with the idea that there was a difference between those two cases. But from his standpoint, it would be that the wealthy individual trying to avoid taxes would be a much more worthy client, which just illustrates the point that we live in a highly pluralistic society, and David Luban, Bill Simon to some extent, and Deborah sometimes sound as if they think that, of course, everybody would agree with them about the moral concern that they have, which I don't think is true. But in any event, it suggests to me that if the idea is that lawyers are supposed to be guided by moral values, in deciding how to go about representing clients, as well as deciding which clients to accept and which ones to reject, that was going to lead to a quite unstable situation in our legal system. So Brad, I think, to his credit, has found a way not to completely take moral considerations out of the game, but nonetheless to be much more interested in the application or implications of political philosophy for legal ethics rather than moral philosophy. And he wants to stress that the overriding consideration for lawyers should be to represent clients in a way that is faithful to the law. Fidelity to law is the overarching value. I like that, but I have questions. We discussed it a little bit last night about sort of implementing the program. Let's put it that way. Fidelity to law implies, for Brad, that when you think about the proposition, lawyers should zealously represent their clients' interests within the bounds of the law or up to the limits of the law. He says that lawyers all too easily glide from that proposition to putting the emphasis completely on pursue client interests. And since we all agree nowadays anyway that there's some significant degree of indeterminacy, not total indeterminacy, I think that's ridiculous, in law, it would mean that lawyers could, without getting into trouble and maybe even thinking that they had an obligation to do this, take positions for clients, not only in litigation, not only in criminal defense work, but in giving compliance advice, counsel to clients, in writing legal opinions, third-party opinions, let's say, such as law firms might write about the fact that the supposed benefits of a tax shelter plan would actually be realized, even though that was very dubious, certainly from the Treasury Department's perspective. That's not fidelity to law. And so then the problem of line drawing becomes really important. And it becomes really important, I think, because if you understand the force field in which lawyers operate, the force fields in which lawyers operate, because there's quite a bit of variation in that, then you understand that there are often very substantial pressures to approach your work this kind of way, even when you're writing opinions or giving compliance advice. And Brad says, and I think this is right, and I tell my students this, and they're quizzical about it at best, in those roles, lawyers ought to really be thinking about the law and what the law means as a judge would. It's not you're not in the mode of zealous advocacy in that situation. You're not in the mode of thinking, is there some colorable possible interpretation I could put on this that would make it permissible for you to go ahead and do that. He wants lawyers to assume a state of mind in carrying out these tasks that takes the law seriously, takes fidelity to law seriously, and will not advise clients that, you can go ahead and do this, because he can think of an interpretation of the law that meets the straight face test, what Brad calls the straight face test. But the question is how, given that lawyers are operating in this force field, to get lawyers to make the kind of reorientation to the law that Brad has in mind, which I think would be wonderful if it would happen, although it's a little hard to say because I don't know exactly how the line drawing is going to work. And I'd certainly like to see more, of an effort to spell that out. if we say that, well, I mean, he makes statements like, well, colorable is not enough, but, you know, and is there some, with respect to taking a position on the tax return, there's the question of how plausible does the position have to be, and I'm not talking about the question of penalties and that sort of thing, but how plausible does it have to be to justify the lawyer advising the client that it would be permissible to take this? And there's been some effort to quantify this, and you know, a 1/3 chance of being acceptable. A reasonable possibility of success if litigated is something that the ABA Ethics Committee came up with in an opinion here. He's got ideas about the craft of lawyering and that give you, I think, very substantial and wise tests for lawyers to use in addressing these sorts of questions. But there's still going to be an awful large gray area there, and even this kind of cogent writing and the exhortations that go with it, I don't see as necessarily having much of an impact on lawyers, given the force field in which they are operating. And I'd like to see a little more attention to the structure of incentives that might help to move lawyers in that direction. He mentions, for example, that lawyers who write third-party opinions have to worry about whether they might become liable to third parties who rely on those opinions if they made statements in the opinions about the law that proved to be inaccurate and were relied upon to the detriment of the third parties. And that certainly is something that helps to keep lawyers from making, you know, terribly extravagant interpretations of rules. But I'd like to hear some more about that too. Thank you.
Thanks. It's a great pleasure to be here. And I have a lot to say about Brad's book, I think, and so I'm probably going to read a little bit more than I otherwise would, especially since I'm the last one, for which I am to blame.
Alphabetical order.
Right. So Brad Wendel's new book, Legal Ethics and Fidelity to Law, is a remarkable achievement for any number of reasons. It offers a defense of the standard conception that is at once novel and traditional. It generates a general normative account while attending with remarkable subtlety to different contexts. It embraces client loyalty more seriously than any other work in recent years, while also taking the social good and broader political values very seriously. And it does all this without demanding much by way of faith in the goodness of human nature, which many other legal ethics scholars have to put forward, and without taking on some ambitious positions in moral epistemology, which, for example, I think Bill Simon has to do. This is, in many ways, the kind of book law professors aim to write, for Brad has synthesized his prior work in a way that is fresh, challenging, riveting, and relevant. He has planted his flag in a particular territory and claimed this important theoretical position as his own with this book. So what is the position? I understand it to be in some ways an extension into legal ethics of a form of legal positivism that is rooted in contemporary social contract theory. It has affinities with Kant, with Hart, with Rawls, with Rouse, and with Jeremy Waldron. I think those are probably the five most important figures. And it says the following: law permits societies to function and flourish, notwithstanding pervasive social disagreement about morality, because the law represents a kind of settlement or agreement. Citizens' compliance with the law permits this settlement or agreement to be realized in social action, rather than just being the law in the books. As Hart saw, legal officials' agreement to count certain kinds of norms as the criteria for law is part of what makes this possible. Moreover, as suggested by Hart and Ross and Waldron, pluralism in value is best finessed through law if the criteria for what will count as law permit social facts to be used to identify the law. In other words, you don't have to go around making moral decisions to decide what the law is. Citizens have a prima facie duty, a prima facie moral duty to obey the law. This is a moral duty whose content is supplied by a political process. In other words, what it is that each of us as a citizen has a duty to do is complied with the law, but the law is put there through our political processes. In this sense, as Ted mentioned, it's a duty rooted in political morality. So where do lawyers fit into this picture? As I understand it, they fit into the picture in two ways. First, and to my mind most importantly for Brad's book, the law is complicated, and citizens who rightly wish to understand what the law is telling them they must do, and also what they may do, and also what they are empowered to do, cannot in fact access this knowledge about the law very easily by themselves. Lawyers advise clients both on what the law tells them they're legally required to do, and also on how they are to go about accomplishing what they want to accomplish. Brad considers the role of counseling, the role of facilitating transactions, as well as the role of litigating. So the upshot is that, remarkably, a version of the standard position in legal ethics is shown to be consistent with, and perhaps even demanded by, a very appealing post-Enlightenment political morality. It is not clients' interest per se that lawyers are supposed to be advocating zealously, but their entitlements. And it is not moral advice that lawyers are supposed to be giving, but legal interpretations, which in turn play into obligations of clients that exist by virtue of political morality. So the lawyer's role is then fundamental to the possibility of a political morality that permits individuals to do what they ought to do and societies to flourish, notwithstanding pervasive disagreement. See, he's nodding, so I'm basically getting the theory right. Okay. And he thinks it's a pretty good theory, too. That's why he's nodding. Yeah, that sounds good. I agree with an awful lot that's in this book, but that wouldn't be much fun to talk about. So I want to talk about two concerns I have with Brad's theory. I think I'm going to end up focusing much more on the second, but they are. First, I'm skeptical that an entitlements-based theory of legal ethics can come close to accommodating the range of conventional judgments in legal ethics that Brad would wish to accommodate and that I think must be accommodated. So I have problems with the entitlements foundation of the view. And second, and more importantly, or at least more long-windedly for me, I worry about the contentious view that there is a moral duty to obey the law, and I worry that it's not adequately defended in this very ambitious book. And actually, as to each of these, I have sort of a patch that I recommend, but I'm not going to get to the patch on entitlements, partly because I don't really know what it is yet. But I will get to the patch on the duty to obey the law. Okay, so Chapter 2 is called From Partisanship to Legal Entitlements, Putting the Law Back into Lawyering. Its primary objective, says Brad, is to, and I quote, is to establish as the first aspect of a conception of legal ethics centered on fidelity to law, that the legal entitlements of clients, not client interests, ordinary moral considerations, or abstract legal norms such as justice, should be the object of lawyers' concerns when acting in a representative capacity. So, just to boil it down, entitlements are what lawyers should be concerned about, not interests, clients' interests. Okay? Now, I don't see how this view is going to work, and I have examples in litigation, transactional, and counseling settings, but the most straightforward one, which is flagged as being straightforward because I use black acre and white acre, goes like this. So black and white live on black acre and white acre, and they're adjacent to one another, and somewhere in between is a nice natural rose garden, and black goes around snipping off the roses, And at some point, White's daughter becomes a lawyer, and she decides to look at the deeds, and she decides that it's actually White's rose garden, not Black's, and there's a lawsuit that ensues. It seems to me that White's lawyer, it can't be the case that what White's lawyer is, if we can imagine such litigation. What the White's lawyer's duty is a duty to represent White's entitlements, right? Because now remember, Brad is a positivist essentially, and he's kind of an objectivist. So at the end of the day, there probably is an answer to the question of whether it's White's or it's Black's rose garden. But we've got to imagine that these two people might very well have a non-frivolous basis, each of them, for litigating against the other. And so it can't be the answer that the only duty of each is to represent what really is his or her client's entitlement, because then one of them would be doing what a lawyer is not supposed to be doing. And I think we can see these same kinds of problems both in the transactional and the counseling settings. The counseling one I'm not sure about, but I'm most interested in what Brad has to say about counseling, so I'll give this example anyway. A drug company has a new drug, and it's in a very, very competitive area. As you all know, the pharmaceutical industry does do a lot of these Me Too drugs, but they want legal advice on whether it's going to infringe somebody's patent. And they go to a law firm, and the law firm sees that the other side may well make an argument that it infringes the patent, and it may be not a bad argument, but in fact we've got a pretty good argument that it doesn't infringe the patent, and all considered, we think it's okay for you to go forward. We think that it doesn't infringe the patent, and that it's a pretty good argument. But now it may well be that the lawyer who offers that advice, were she a judge, would actually, at the end of the day, come out on the other side of this. And it may well be that, in some sense, it would be a hard call, but maybe it would be ruled as infringing. There's got to be some space for in Brad's theory, for the lawyer to think if there's a pretty good, respectful and serious argument that it isn't infringing of the patent, then it may be permissible for the client to go forward. But it strikes me that there's still may well be an objective answer in Brad's positivistic framework to the question of whether it is infringing, and if it is infringing, then there's not an entitlement. And so it's just not clear to me how it can be okay for the lawyer to do this. So I do think there's kind of a problem about the shift from interest to entitlements. Let me talk about troubling features of the claim that there's a general moral prima facie duty to obey the law. I'm going to leave aside the point that Brad's commendable candor regarding a wide variety of legitimacy problems which we'd need to overcome, because there's not going to be a prima facie duty to obey the law in an illegitimate legal system. I myself found his very candid and impressive review of all the potential legitimacy problems, unfortunately, somewhat more persuasive than his responses to those legitimacy problems. But the main point I want to make is a little one, and again, I'm not giving the most crystalline examples, and that's because my intuitions aren't as strong here as they are in torts. But here's the example. So sometimes I want to focus on cases in which it's far from clear that the person who does not do what the law requires is violating a moral duty. Now, sometimes these are cases where the prima facie reason for obeying the law is overcome, but in others they are not cases. And my problem is going to be that I think there are going to be two categories here. So it is illegal to drive in New York State without a valid driver's license. The law requires that if X's driver's license is not valid, X not drive. If there's a prima facie moral duty to comply with the law, and X's driver's license is out of date and therefore not valid, then X has a duty to refrain from driving. Now, suppose X's child is ill and must be rushed to the hospital. Here it is tempting to say that maybe X does not have a moral duty to refrain from driving. Maybe X's prima facie moral duty to refrain from driving is overcome. But now let's try another case. X wakes up in the morning and realizes there's no milk in the house for the kids' breakfast. He can hop in the car and pick up milk at the grocery store a mile away. He realizes that or 2 miles away, because I don't want any of these, well, why doesn't he walk claims. Okay. He can hop in the car and pick up the milk. He realizes that his license expired the day before and he forgot to renew it. Does X have a moral obligation to stay home? Would it be immoral for X to jump in the car? I think Brad's position commits him to saying yes in many cases like this. And there may be reasons that I agree that there's a reason that he shouldn't drive, but I think the language of saying he's a moral obligation not to drive here is questionable. The general point is not that there are sometimes good reasons for disobeying the law or not. The point is that the qualification prima facie, I think, is going to have to be stretched, watered down too much if we wanted to handle the milk case. It won't carry much normative force at all. But if we just need to say then there is a prima facie moral duty in a case like the milk case, it becomes a somewhat pedantic seeming view, or it has that risk. So what is my response to all of this? Because I'm really almost out of time. So what Brad and I agree on, and it's a very strong area of agreement, and the torture case, as well as the Enron cases and many, many others that he beautifully describes are great examples of this, is that in counseling, lawyers have a duty, even if there are many different interpretations of the law. They have a duty not just to pick the one that's most favorable to their client. They have a duty to give a pretty authentic sense of what reasonable interpretations may be. Now, my view is that one can give that sort of theory of legal ethics without the premise that individuals have a moral obligation to obey the law. Moreover, that premise about what lawyers have a duty to do in counseling, that contention, is one that I think is connected to his overall vision of the political role of lawyers in society, that lawyers help people to comply with the law, which helps the law to function, which helps the society to flourish. But I don't think he needs as a premise that there's a moral duty to obey the law. And in fact, Hart, who in many ways is an inspiration to Brad here, did not, it's not clear that he held the view that there's a moral duty to obey the law. Certainly that is not at the core of the concept of law or of his famous essay in the Hart-Fuller debate, although he later wrote about it somewhat. Hart's view on obligations in the concept of law is that legal obligations and moral obligations are two species of the same genus. And there is a certain kind of social norm that people perceive as imposing a certain kind of pressure upon them to behave a certain way. And they conceive of those social norms as being there, in a sense, to secure a variety of social goods. They understand what the content of those social norms is as something that is important to them. And I think it's quite plausible to say that we have a huge number of actors in our society who do, in fact, care a great deal about what their legal obligations are, and learning that something is a legal obligation is an important and significantly incentivizing fact to them. And even if there's not a moral obligation to comply with all your legal obligations, the lawyer's role may well be to illuminate what people's legal obligations are. And we can leave aside, not entirely, as it's an important topic of debate, but we can leave aside for some of these purposes exactly what the nature of the moral obligation to comply with the legal obligations are. It's a significant fact that they're legal obligations, and obviously in the case of the torture memo for government officials, it's an incredibly significant fact that these were legal obligations that they were failing to comply with. So on that note, I'll conclude, and thank you for inviting me. This is a wonderful book.
Everyone bolts for the exits, geez. I feel like I want to use most of my time just expressing gratitude. I'm just enormously gratified for this occasion, and I want to start by saying thanks to Stuart for starting this fantastic tradition of book celebrations. I think it's a wonderful way for all of us to get together and hear about what our colleagues are doing and ask them hard questions and celebrate their work. And so I think it's a wonderful tradition. I'm glad we're continuing it. Thanks also to Eduardo for putting in the hard legwork, getting people to come and calling and emailing and taking people out to dinner and all that good stuff, without which we couldn't have these occasions. And really thanks to the three commentators for traveling, in some cases a long way, or in some cases on a short and harrowing flight, up to be here. And it's just really, really wonderful to have an ongoing dialogue with all three of these folks. And I think this occasion here is just one in a series of conversations that we've been having over the years. I sort of feel like it only goes one way. I learn from these guys and just try to make my own work better in response to what they do. And so to have them read and reflect on what I've written and give feedback is just an enormous honor, and I'm really thrilled. The remarkable thing, too, is to hear them talk about the position in the book and go, yeah, that's exactly what I was trying to say, only you said it better than I did. No one turns a phrase like Bob Gordon, and I really wish I had come up with the line, an all-purpose autonomy engineer hired to hack a path through the jungle. That is the position I'm criticizing, and I'm criticizing that position on the one hand, the sort of standard conception that lawyers have an obligation to protect their clients' autonomy or interests or whatever, as long as they don't transgress some clear legal norm. That's the opponent on one side, and the opponent on the other, as Bob and Ted both really well described, is the kind of moralistic conception of legal ethics associated with people like David Luban and Deborah Rohde, in which the primary fact for legal ethics to deal with is the persistence of moral agency. The idea that people remain moral agents even when acting in role and have an obligation to give a justification in moral terms for what they do. And, while I really argue against Luban and Rohde and Wasserstrom and people like that in the book, I have an enormous respect for their position, and I take it as a major project of the book that I have to figure out some kind of moral justification that a lawyer can give from within the role that answers to this problem of moral agency. And that's what leads me down the path that Ben identified as problem number 2, and that's probably the thing I'm going to have the most to say about in this response. And I think it's probably the hardest problem that I had to deal with, which is bringing together the obligation of obedience to the law and morality somehow, whether I did it in too strong a way by relying on a prima facie obligation to obey, or whether there's some workaround. I think that's kind of the big open question that I have in the book. A couple of quick responses, though. To Bob Gordon, yeah, Bob's not the only one who thinks Bill Simon and I are saying the same thing. Bill Simon thinks that too. Whenever I see him, he always hectors me into trying to agree that I'm saying the same thing he is. I think we are saying the same thing at a theoretical level, but he then uses his position to waffle to the answer that he wants. And so I think where we differ is just in how seriously we take our jurisprudence. He wants to claim to be articulating an obligation of fidelity to law. I don't think he would use that terminology, but he would say that a lawyer's obligation is to justice. Justice is understood as legal merit. Legal merit is understood in a positivistic way. But whenever you have a hard case in legal ethics, it's remarkable how Bill's position winds up agreeing with the kind of left-of-center Democratic Party platform, which is my own political view as well, but I am not so arrogant to believe that others agree with me about this. And so I just find it kind of odd that Bill's jurisprudence always works out to support the results that agree with him politically. And I think what's going on there is a bit of slipperiness with Dworkin. He calls himself a Dworkinian, and I think he is a Dworkinian. But Dworkin is pretty clear in saying that an interpretation of law has to fit with past political decisions and also the community's political morality. I think what Bill does is smuggle in a kind of critical political morality. And what legal merit turns out to be on Bill's position is what is a better view in some kind of moral term, as opposed to the community's conventional moral view. So I try to take seriously the community's conventional, not morality, but law, because I think that is the right way through this morass of disagreement. I think Ben does a nice job of saying that I'm really drawing from Hart, Raz, Waldron, Rawls, and others, and contemporary social contract theory, trying to give content to the idea that if there's something good about what we do as lawyers, it is to enable but it's to enable cooperation and coexistence and working together on common projects despite deep and persistent moral disagreement. I think if there's any value in what we do, if our profession is something noble, if we are lawyers in the best sense, to use the Cornell catchphrase, then it is because we contribute to this socially beneficial project. And so that's what I'm trying to capture here, and I think that does require sometimes holding your nose in hard cases and saying, well, it may be a crummy law, but it's the law. And so I think that's where Bill and I disagree. I like Bob's question about fidelity to facts, and whether an implication of my view is that lawyers have an obligation not to play games too much with the facts and discovery and depositions and things like that. One of the readers of the manuscript really pressed me on that, and I tried to shore up the manuscript in that way, but I don't think I did enough. I think I got a little nervous. This is something Ben also mentioned, that it's hard to square the position I'm taking here with certain conventional judgments that people in legal ethics subscribe to. It's kind of a reflective equilibrium story. If I get too radical, then I have a hard time situating myself in the field that I want to try to provide an account for. Bob said this too in his comments. He said, I may be more radical than I'm claiming. I'm sitting here putting on this pose of modesty, but actually taking a very radical position. That may be the case. I think you can deal with this problem a little bit by using the idea of legal entitlements, which is to say facts don't come into the legal system without law. The facts enter the legal system via rules of civil procedure, laws of evidence, and things like that. And a lot of what we call playing games with facts can be dealt with under the rubric of discovery abuse and things like that. And so to the extent we're worried about something short of outright fraud or deception that just seems to be game playing, one way to handle that would be to say a objective, honest, good faith interpretation of the law governing discovery or something like that wouldn't permit this. So there's a pretty well-known example in the legal ethics literature about discovery abuse in a products liability case. The A.H. Robbins lawyers defending the company in the Dalcon Shield litigation figured out that they could scare off a lot of the plaintiffs in that case and induce a lot of early settlements by asking lots of really, really embarrassing questions and depositions about women's sexual practices. And if these questions were persistent and creepy enough, eventually the women would settle their cases. And I think it's pretty, not easy, but I think one way to handle this is to say, look, the lawyers didn't have a genuine legal entitlement to do that. They may have been able to get away with it because judges don't like to supervise discovery disputes, and the judge was disinclined to grant motions for a protective order in this case. But that doesn't mean there's a real legal entitlement to ask these questions. And so the problem of fidelity to facts, I think, can be turned into analysis in terms of fidelity to law. At least that's one thing I tried to do in the book. I don't think Bob quite buys that. I also like Bob's question about whether there are implications for lawyers acting in a non-representative capacity. I don't want to overclaim here. I think a lot of what I tried to do in the book is just characterize the normative situation of lawyers who are representing clients, either as litigation advocates, counselors, advisors, transactional planners, whatever. I don't really claim to be offering a general theory of political morality or a general theory of a just society or anything like that. So I really left it as an open question whether the sorts of values that inform lawyers acting in a representative capacity have an implication for lawyers acting in a non-representative capacity, that is, as agents for political change. I really haven't thought about that at all. It's an interesting idea, and I think I would have to go back to some of the underlying political theory that I deal with and see if one can get to an obligation to, as Bob says, to maintain the stability of the framework. And for us as a legal profession, to take some responsibility for maintaining the legal system in good working order. Intuitively, I think we do have that responsibility, but I'm just not sure if you can trace it back to the same foundations as I do where lawyers are acting in a representative capacity. Ted asks whether the concept of entitlement is sufficiently stable to do the work that I need it to do. And that was really a problem that I faced throughout the writing of the book, was how much do I want to lean on legal determinacy? And I don't for a moment want to suggest that I believe that there is only one objectively right legal answer to any given question. And I don't want the notion of entitlement to seem to stand for the right answer. It's more like a regulative ideal in my theory. It's more like the thing that we're arguing toward, or the thing we're arguing about when we talk as lawyers. It's not so much that an entitlement is this objectively existing fact of nature waiting to be discovered, but it's the thing that we're constructing or the thing that we're doing when we engage in the craft of lawyering. So I would see entitlements not as an either-or, not as a binary kind of concept, a client has an entitlement or not, but rather as an idea that expresses the plausibility of the argument that a client could give in legal terms in justification of its actions. So I'm very comfortable with situations, both in litigation and transactions, where a lawyer says, geez, Ben had an example of, does this drug infringe the patent? I don't think that the idea of entitlement is supposed to sort those cases into yes, you can, no, you can't. I'm comfortable with the middle ground case where a lawyer says, geez, I could see arguments going the other way. Maybe even if I were a judge, I would say the drug does infringe the patent. But I think there's enough here. I think you have enough plausible arguments that you could raise for non-infringement that you would not be acting illegally. You would not be acting in bad faith. You would not be exhibiting infidelity to law by marketing this drug. So that's really all I need. I don't want too strong a notion of entitlement in the work, and I don't think I relied on anything too strong, but I also know I may have weaseled around a little bit in the stuff on interpretation, because this is hard. There are very few cases in which it's clear that a lawyer is simply making frivolous arguments. The torture memos may be one of them, but there aren't many cases beyond that where a lawyer is making just flat-out frivolous arguments, and so I rely on this kind of spectrum of plausibility that may seem too squishy, but that seems faithful to the way lawyers deal with the law in practice. Oh, and and then Ted also raises a very powerful practical consideration, which is, this is all well and good from the 37,000-foot level of philosophy, but what are you going to say to a lawyer who is asked to draft an opinion letter, and the client says, not in so many words, but this opinion has to come out permitting us to do this, right? And we'll take our business elsewhere if you won't do that. I recognize there's a lot of pressure here, and I don't for a moment pretend that a work of academic legal ethics is going to fortify lawyers and enable them to go in to the CFO of Enron and say, hey, Andy Fastow, go pound sand. I'm not going to do this transaction. I realize that this is very, very, very difficult in practice. I don't, as I think it was Bob or Ted, one of the two said, or maybe Ben, one of the commentators said that I'm not relying on a lot of assumptions about innate human goodness, and that's true, and I'm certainly not. And so I'm also not relying on a lot of assumptions about the power of education to change behavior. I don't think if everyone runs around teaching my book and training lawyers up this way that they're going to suddenly develop a backbone and stand up to powerful clients. I think this is difficult. But I do think I only have the somewhat more modest task of trying to characterize rightly what makes lawyers act right or wrongly. How do we deal with centers of power and pressure on lawyers in practice to make it more likely they will comply? That's a completely separate question, one which I confess complete ignorance about. I don't really know. There are some things you can do, and I try to talk about liability. Possibly you can change liability rules. one of the things we do in teaching is I emphasize cases in which lawyers are liable for giving bad legal advice. There's a great case called FDIC versus O'Melveny and Myers, one of my favorite teaching cases, where the lawyers advised a client that what it was doing was lawful, when in fact it wasn't, thinking that the advice would be shielded by the attorney-client privilege and the lawyers would get off scot-free. Well, lo and behold, the bank went into receivership, and the receiver came and waived the attorney-client privilege and went after the law firm as one of the actors that contributed to the fall of the bank, and said, you know, this law firm here should have assets that depositors can recover against because of the wrongdoing of the law firm. And the law firm's advice was the basis of, in effect, a negligence lawsuit against the law firm for providing lousy legal advice that allowed the deepening insolvency of this bank. And so there are cases like that that you can use and say, look, it's not just a notional possibility that a lawyer may be held liable for providing bad legal advice. It happens. These are big dollar claims. And this is the kind of situation in which lawyers really do need to care about the obligation of fidelity to law. There aren't as many of those cases as I would like, but they're out there. It's not a mythical possibility. But I agree that it's a really hard problem. You know, I'll say only something very briefly about Ben's second concern. I think it's a really hard problem. I struggled. I went round and round and round about how to connect up the settlement-based with social contract theory foundations of the book with obligations for lawyers. And there are kind of two paths one could take, a direct path and an indirect path. The indirect path would be to say citizens have a prima facie obligation to obey the law, and lawyers therefore have a derivative obligation of fidelity to law when they act as agents of citizens. The direct path would be to say all of this stuff about legal obligation creates obligations on the part of lawyers. Forget citizens. We can just leave them out of the picture. We can just say lawyers have obligations directly to the legal system. The thing I wanted to avoid, however, is Hart's distinction between legal and moral obligations as being simply two species of the same genus of obligation. I think that's an interesting view, but it seems to me to leave open the question. So if someone says in a Hartian mode, well, I have a legal obligation to do such and such, or a legal permission to do such and such, it just seems to invite the question, so what? Why should I care about that? Because I take it that when you affect my interests, you have an obligation to give a moral justification for doing so. I think morality is, to quote Thomas Scanlon, morality is about what we owe to each other. And when someone impinges on my interests in some way, I'm entitled to demand a justification from that person. Why did you do that? And I expect them to give me a justification in terms that I can endorse. And the response, I did that because I was legally permitted to do that, just simply pushes the question back one more level, and I say, well, fine, you're legally permitted to do that, but who cares? What relationship does the law have with morality? What kind of justification is that? And I tried to make this norm expressivist move, and I don't think Ben's going to buy this, but the move I tried to make in the book is to say, to the extent the law creates moral permissions and obligations for citizens, a citizen can say to someone else, I'm legally permitted or obligated to do such and such, and that gives me some kind of justification that you have to respect. Now, I do acknowledge the problem of sounding pedantic. I think it's a good way to put it. You know, when I express the analysis of the lawyer, of the citizen with the driver's license who goes out to get a gallon of milk, and I say he's committed moral wrongdoing, that does sound kind of priggish and pedantic. It reminds me of Susan Wolf's argument about moral saints. That morality can't possibly be a system that makes most of us wrongdoers most of the time. That we have to be able to recognize that there's a lot of stuff that may not be ideal, but it's really not a big deal. And in a case like that, I might say maybe the term moral wrongdoing is overblown, but I also don't want to take the wrongdoing out of the picture entirely. I don't want to say someone didn't renew their driver's license, they drove anyway, so what? I'm willing to say, okay, it's not a very big deal. I'm willing to say that if I park at a parking meter and don't put in a quarter and I get away with it, it's not a big deal. The earth is not going to stop revolving around its axis. But I'm also not 100% in the clear. I have not behaved entirely honorably. It's a very, very small demerit. It's a ticky-tacky moral wrong, but it's a moral wrong nonetheless. And I don't want to take that off the table because what I'm really concerned about is not the citizen going out to get the gallon of milk, but the lawyer advising the citizen on whether it's permissible under the law to drive without a driver's license. And I don't want the move which you often see in Lubon and Rhodey's work, to be made where we say, well, this really isn't all that big of a deal as a moral matter, therefore the lawyer should be permitted to advise the client to ignore the law. That's, I think, their analysis of that welfare hypothetical. The welfare system is more or less unjust anyway. It's kind of a ticky-tacky violation of the law. The client is deserving. Who cares? That seems to be their analysis. I may be exaggerating a little bit, but I want to block that move. I want to resist that move. And if it takes being a little bit pedantic, I can live with that. But I am concerned about the problem of needing to use, a sledgehammer to swat a fly and bringing all this apparatus to bear of a moral obligation to obey the law when really all I need is to give an account for why lawyers have an obligation to take the value of legality seriously. That's certainly something I struggled with, and I think Ben's exactly right to identify that as a big problem. I won't say more. I know we only have about 10 minutes left, and you guys have been so good as to stick it out. So I want to give you time for questions. Bob Hillman at the back. That's okay. Only my immediate family and these three guys have, so that's okay. No, very, very much so. I do make that distinction, and I think this goes to Ben's example about the rose garden. What I say in the litigation example is that all actors in the legal system, judges, lawyers, have an obligation of fidelity to law, but it can be distributed among different actors in different ways depending on the necessities of the institutional context. So in litigation, there is a kind of a systemic obligation of fidelity to law. But that's dealt with by practices such as adversarial briefing and appeals and judges and law clerks and things like that collectively work together to get the right legal results. So in a litigation context, I don't put the responsibility only on one of the lawyers to act with fidelity to law. Another way to put that is the legal entitlements structuring what the lawyer may do in that situation include the entitlement to plead plausible arguments in defense, to withhold information if there are applicable privileges, to raise non-frivolous legal arguments in opposition. So even if the lawyer representing white or black or whoever it is, who believes really that this is the other guy's rose garden, is permitted to say, well, I've adversely possessed the rose garden, or I have, necessity allows me to cut the roses, or whatever. I don't know. Eduardo's over here, frowning at me. I don't know anything about property law, but presumably there are some sorts of arguments that one might raise, and lawyers have an entitlement to raise those in litigation. The reason is because we think the litigation system structured in that way does a good job of accommodating the competing concerns of stability and also, where's the little thing? A law must be stable and yet not stand still, right? So that's the overall objective of the litigation system, and in order to accomplish that, you need to permit lawyers to make non-frivolous arguments, even if they believe that the entitlement maybe might ought to go the other way. I got Ori, Mike, Steve, and Valerie in the queue. Mm-hmm. Yeah.
The argument would be a lawyer has justification to do whatever he does based on political morality, and it's a stable and good argument, and beats interpersonal morality arguments, and that's fine. But many agencies still place it somehow from a moral point of view in relation to Cambridge issues. An example would be the driving a car, the green energy right is the law is legal. Can't you make the same argument for lawyers, right? That represent equal people, right? And the lawyers do whatever the lawyers have to do, and there's complete fidelity to the law. There's no originality, there's no determinacy, they're not doing anything effective here. But still, there's a person who helped the mass murderer get off, helped Enron do whatever they did. Are they not somehow morally implicated, nevertheless?
Yeah, no, that's a great question. You say moral taint. I talk about the problem of dirty hands or moral remainders, to quote Bernard Williams. And I have a whole chapter in the book on that. And I was actually waiting to be just walloped for that by someone on the panel, because I think the idea that plural and conflicting obligations can generate moral remainders is considered a bit of an oddball position in political philosophy. There are people who subscribe to it, Michael Walzer, Bernard Williams, and people like that. But the mainstream position in political philosophy is you either have an obligation or you don't. You either have a permission or you don't. You do the all things considered moral reasoning and you say this is what your obligation is. But if you believe in plural spheres of obligation, let's take Ben's thing from heart about legal and moral obligation. If you believe that you may have different kinds of obligation that may point off in different directions, you may believe that one of those has deliberative priority over the other. That this is what I ought to do in this situation. But the other obligations don't just go away. They're not just canceled out. They kind of hang around and they create lingering, as you say, a lingering sentiment of having done wrong, even though having acted with justification. And you're right that people ought to feel a certain way. They ought to feel a sense of regret or a sense of guilt, and possibly that sense of regret or guilt may generate obligations of reparation or some kind of atonement in the future, even though the lawyer believes this is the right thing to do. So I talk about several cases in the chapter. One of them is a case that David Wilkins has written about very interestingly, about an African-American lawyer for the ACLU in Texas who represented the Ku Klux Klan in a case, one of these adopt a highway cases where the Klan wanted to put Klan signs all over the place. And Texas said, no, you can't do that. And an ACLU lawyer volunteered to represent the Klan. It just happened that the lawyer is African American. And, Wilkins says you can't, it's facile to say either the lawyer is justified or he isn't. A more plausible way of understanding that case is to say maybe on the basis of the civil rights commitments this lawyer has, the lawyer did the right thing and did something admirable. But it'd be crazy to think that the sense of having assisted the Klan in its nefarious project just goes away, and that the lawyer just kind of goes home and sleeps easy at night and says, oh, that was, what'd you do today at work, honey? Well, I represented the Grand Wizard of the Ku Klux Klan. Oh, that's nice. That's kind of a facile analysis. So I'm very attracted to the idea of moral remainders and dirty hands. I'm not certain how much work I want it to do, but I do address that in the book. It's an interesting possibility. Mike.
So two very quick comments that we don't need to say about that. Short question. So first, on the distinction between you and keep going. Sorry, that's right. Between you and Bill Simon.
Yeah.
Right? It reminds me a little bit about what people sometimes say about work. Right? So one says people complain that my work has happy endings. Right? And so then there are a bunch of people who try to do as Dworkin says, not as he does. Right? Jim Fleming is written these things, right? So you were playing that role relative to Simon.
Okay.
Second point is on your disagreement with Ben about the foundation law to obey the law. It seems to me what you want to do is you want to collapse all normative obligations into moral obligations. Right? It's not a moral obligation, it's not an obligation. But I think that that's problematic, right? Because what about obligations of politeness? Now you could think of politeness as a kind of subcategory of supererogatory moral duties, which I think you could do, but I think that's forced. I think it makes more sense to think of politeness as its own sort of set of people, right? At the end, right? It's not structure. And the law makes more sense that way, and it certainly wouldn't be a supererogatory.
No, right. Yeah.
Now the question. The question is, where does the obligation to treat the law as the regulative ideal come from? It strikes me as at least you need a justification. If I go to a doctor, right, there are some respects in which I expect the doctor to think of medicine as the regulative ideal. Right? So if I say to the doctor, I would like some morphine, you have a terrible pain. No, I just hear it's a good high. Right? The doctor is legally, and I would assume by medical ethics, prohibited from giving even morphine. On the other hand, if I say to the doctor, I've got this terrible back injury, so I'd like to give you a shot, and I say, no, I don't want to treat with shots, the doctor can then say, well, you really ought to, but if I still refuse, the doctor is going to want to treat my pain the next best way he or she can. And that seems to be perfectly appropriate. So we wouldn't say that in medicine, a doctor always has an obligation to have the best medical treatment to the regular ideal. So why do we want to say that for a lawyer, the law?
Yeah, okay. I will answer that, but I want to give everyone a chance to go who needs to go. It's now past our 1:45 stop time, so you're now officially released from your obligation of etiquette or collegiality or whatever, however we want to characterize this. So you guys can go, and I'll try to answer that. I think the best answer I can give sort of runs into Ben's objection again, and that is I really wasn't in the book trying to give an account of the obligations to do everything. What I really want to do, the most modest aim of the book, is to understand what lawyers are up to and understand what the value is of lawyering in normative terms. Why do we care about this practice? And so I'm not so much interested in the question of you go to the doctor and you and the doctor have this interaction and you're trying to figure out, what norms structure that interaction. Are they primarily legal obligations? Are they ethical obligations of a doctor? Or are they sort of interpersonal obligations? I'm less interested in that than I am in understanding the question when the lawyer gives advice to the medical practice about dispensing drugs, what considerations does the lawyer have in mind? So Ted last night raised an interesting question that just came up in Arizona. So Arizona just passed by state referendum a medical marijuana permission law, but the chair of the Arizona State Bar Association said it would be unethical for lawyers to participate in setting up a medical marijuana dispensary in Arizona because it's still unlawful under federal law, and they'd be counseling or assisting violation of law. Now, I happen to think the criminalization of marijuana is stupid, but from the standpoint of the lawyer giving advice to a medical marijuana dispensary, I want to make sure that the lawyer's obligations are to the law, to interpret the law in good faith, and not to come up with loopholes and to weasel around the law in some bad faith way, just because the lawyer thinks, with justification, that the federal prohibition on marijuana is stupid. So I'm really trying to characterize the morality of lawyers in doing what they do, as opposed to the morality of all people interacting. It's just that to get to the morality of lawyers doing what they do, what I do is posit the situation of people interacting and needing some basis for doing so that they can refer to as a way to supersede disagreement. So the law provides a way for you and the doctor or whomever to say, look, whatever else we think about what I ought to do in the situation, here's the baseline, here's the law. The law says you should or should not do this. And that's pretty useful. And so the value of lawyering as an activity is derivative of the value of the law in that way. But I'm not claiming to offer a general account of the way people ought to interact with one another. Steve.
I realize, I think your book really sounds terrific, though it's made it clear to me that in your eyes as a financial lawyer, and I don't think so, but I just want to check two examples. One is the fact that they both involve repeating the defamatory statements, which in defamation law is protected under certain kinds of circumstances with certain privileges.
Reporter's privilege or something, yeah.
Actually, well, reporting on trial. But there is no protection for reporting in New York or California, for example, on press conferences. So that in New York, if you report on a press conference and that person is defaming somebody else, you can be held liable for reporting unless it's in the federal with First Amendment protection. But if it's in the state court, the First Amendment interpretation is different. So I'm advising a newspaper, and I tell them, go ahead and do this, in which you're defaming, because although under the law you have New York Times malice, because the reporter says, I don't know, I have records disregarded.
Right.
I'm just reporting on the facts. Even though you have New York Times malice, well, the likelihood is overwhelming that you will not be sued. Because if anybody's going to be sued here, it's the person who gave the press conference. And it's very unlikely that you're going to be sued because And the second example is you have two private persons who have said things about each other. Incredibly interesting story. The report involving the welfare system, which reveals truths about the welfare system. You ask, is your client, is the welfare person here, do you believe that person? I don't know. But it's really an interesting story. So you change the names, you change the details to minimize the possibility of defamation. But you know that if somebody sues, you're going to lose. Unless you can get the law changed, which is a possibility, but unlikely. And it strikes me in these cases that it's not a criminal circumstance. You know, it's not like you're violating the criminal law. You're defaming somebody. There is a low probability that you can win. And it strikes me that it's not a litigation context, which of course you defend it. It's counseling.
Yeah.
So how do you think?
No, I think, gee, it's a hard question. No, I think about that a lot, and I'm really uncomfortable with the advice that you give. Now, at the same time, what I don't want to say is that lawyers have to give the following advice. You can't do that, period, end of story. It's unlawful and, bad. I don't want lawyers doing that either. I think a lot depends on context, and this is very subtle. So it's possible to give the kind of disclosure that you just did in a way that encourages the lawyer to break the law. And that makes me uncomfortable. On the other hand, obligations of candor in communication with clients require you to give all of the information that you gave. So I think it's a really, really tough problem to give a categorical answer to. I think I would say more or less what you said. But make sure to say to the client, but look, you have to understand that what you're doing is in violation of state law. And it's not just a risk. The thing that I really want them worried about, and I think Bob mentioned my revulsion at the idea of law as price, or the Holmesian bad man view of law. I don't like the idea that you can say to your client, well, you can't do this, but look, the penalty is going to be kind of inconsequential, so who cares? Go ahead and breach and pay. I don't like that. But at the same time, I don't think it's appropriate to categorically say it's illegal, you can't do that, if there is some basis for believing that it's permissible to do what you're doing. Now, it has to be permissible because the law permits it, not because the plaintiff's bar is hopeless, the judges don't know about this, you can, avoid liability by some sort of institutional malfunction. And one of the distinctions I try to raise in the book and maintain throughout is between an entitlement and some sort of hiccup in the system that allows the client to get away with something even though it's not a legal entitlement. So I would not want to exploit institutional malfunctions under the guise of calling that an entitlement. It's not. If it's not an entitlement, then you can't counsel the client to do it. But I don't know enough about defamation law to know from the facts you described whether this is really exploiting incompetence or whether there is an arguable entitlement there. But that's how I would divide that up. It's a hard case, though.
An indication that you would have a chance of prevailing.
Right, and that's what I'm saying. So right. So if you specify it in that way, if there are enough facts to suggest that it's a problematic law in the sense that it really isn't the law at all, and if it were challenged, a judge would say, this is an archaic law that we never really took seriously anyway, that's different than saying it's a stupid law, but one that is a genuine law. Those are different things. Valerie. Oh, sorry. Okay. Oh, way over time, yeah. Oh, thank these guys, yeah. Mm-hmm. 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 oh, but lawyers are so resistant to that. I should bring Bob up to the podium because he was part of a study, an ABA litigation section study of lawyers' ethics, and he and Austin Serrett and Mark Suchman and a few others did this study where they talked about lawyers' attitudes toward ethical problems. And one of the things that really jumped out at me in that study is the incredible allergy that lawyers have to talking in explicitly reflective moral terms. If you make anything a question about right and wrong, lawyers go, I don't know about right and wrong. You know, who am I? I'm not a rabbi. I don't know this stuff. And they just, it's the, you know, what's Ted's phrase? You know, epistemological skepticism or something. It's just lawyers have no capacity or desire or interest in engaging in that. And actually, from the pedagogical point of view, talking about entitlements seems to work. I've taught a number of CLEs, and I'm actually writing a thing for the Australian CLE provider right now on the torture memos. And if you get lawyers sitting around talking about torture as torture, you get, you know, either this, I don't know, or ridiculous hypotheticals from 24 about ticking bombs or whatever, and it's just a complete evasion of the issue. But what you can do is work through the torture statute and say, this is what the OLC lawyers said about the permissibility of waterboarding in light of this statute. Here's the statutory language. What do you think? And 99 out of 100 lawyers go, I can't believe anyone made that argument with a straight face. And then you can say, well, that's the ethics of legal advising right there. What's unethical about what the OLC lawyers did is that they distorted, manipulated, twisted, abused the law to get their client what the client wanted, and the law didn't permit that. And most lawyers can sign on to that. Most lawyers say, yeah, I get that. But if you start talking in explicitly reflective moral terms, they run screaming for the exits. At least that's what I take to be the conclusion of the ABA, one of the conclusions of the ABA study. All right, I should let y'all go. Thanks for coming and staying past time. I really appreciate it. And thanks again so much to the panel, Eduardo, Stuart,